Good morning. This is the first audio check for captioning. Test 1 2 3. Test 1 2 3. Good morning. This is the second microphone check for captioning. Microphone check 1 2. Microphone check 1 2 3.
Good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, June 28th, 2023. The time is 9:30 a.m. With us today are Commissioners Emily Lindley and Bobby Ginecka, as well as our General Counsel, Mary Smith, and I am John Neerman. For those who are joining us virtually, I'll ask you to please keep your microphones muted when you're not speaking. For those making presentations, please wait to begin your presentation until our General Counsel or I have asked you to begin. On items where argument or discussion is allowed, we will inform speakers of their time limits if we have not done so already. Registration is now closed, but if you would like to address the Commission on a particular item, please email agenda@tceq.texas.gov with your name, your affiliation, and the item that you'd like to speak to, and we will do our best to accommodate that request. With that, thank you everyone for being present, and Ms. Smith, please call the first item.
Item number 1 is the application by MTX Materials LP for new TPDS permit number WQ000533700. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So for those who are not familiar with our process, Chapter 55 of TCEQ's rules lay out a two-step analysis for considering requests for contested case hearings on TPDS permits like the one before us. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And assuming that at least one requester has met those requirements, we then consider which issues are appropriate to refer for a hearing. So Part 1 is about who gets a hearing, and Part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who make timely comments articulating personal concerns that are relevant and material to the application and who express those concerns in a timely hearing request are entitled to a hearing. And colleagues, on this item, we have a single request. It's from Cook's Branch Conservancy. The Conservancy's property is adjacent to the facility. That property is bisected by the discharge route. The Conservancy raises concerns about water quality and ecological impacts affecting its property. The comments were timely. The request was timely. I would grant this request.
I agree.
Likewise.
Pretty easy. Turning to the issue, I've identified the following. I would refer whether the draft permit is protective of wildlife, whether it is protective of water quality, consistent with the state's surface water quality standards, and whether the application accurately characterizes the discharge route. And I would decline to refer the question about the sufficiency of our Chapter 311 rules because that's not properly before the Commission on a permit application. I'd also include an ADR referral and allow 180 days for the hearing.
I'm in agreement. I can attempt a motion if it looks like we're there. I move that we grant the hearing request of Cook's Branch Conservancy, that we refer the application to SOA for a contested case hearing on the following issues. A, whether the draft permit is protective of aquatic and terrestrial wildlife and water quality in the receiving waters in accordance with the Texas surface water quality standards. And B, whether the discharge route has been accurately characterized and described in the application. I also move that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA preliminary hearing scheduling efforts, and that we set the hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 2 is the application by the City of Ennis for a major amendment to TPDS permit number WQ00104430002. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So again, we have a two-part analysis for considering requests for contested cases on TPDS application, and Part 1 is about who is entitled to a hearing. Requesters who are affected in a manner different from the general public, who make timely comments articulating personal concerns that are relevant and material to the application, and who express those concerns in a timely hearing request are entitled to a hearing. Colleagues, on this one, Mr. Layton failed to timely state any concerns about how the proposed amendment would impact his personal interest. Mr. Dias also fails to state how he's affected in a manner different from the general public, to the extent that we want to read his submission as a hearing request. I'm glad we are, to err on the side of caution, but the bottom line is that I would deny both of these requests.
I'm in agreement.
Well said. Likewise. Thanks for making that point on how to read both requesters. I would make the motion that we deny all hearing requests, issue the major amendment to TPDS permit number WQ0010443002 to the City of Enos as recommended by the Executive Director, and adopt the Executive Director's response to comments.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the application by Walton, Texas, LP for new TPDS permit number WQ00159180001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Colleagues, I feel like a broken record, but again, we have a two-part analysis on these hearing requests. Requesters who are affected in a manner different from the general public, who make timely comments articulating personal concerns that are relevant material to the application, and who express those concerns in a timely hearing request are entitled to a hearing. Additionally, since we have some associations on this item, associations can have standing if, among other factors, they identify a member who would have standing in his or her own right. We are looking at 5 requests on this item. The Martindale Water Supply Corporation expressed concerns about the potential for its source water to become contaminated, and it has met the other procedural and substantive requirements in my view, so I would grant its request. The San Marcos River Foundation and the Texas Rivers Protection Association also meet the requirements in my estimation. They express concerns about water quality, and they identify Frank Caldwell as a member who would have standing in his own right. Mr. Caldwell's property is within roughly 500 feet of the proposed outfall, so I would grant this request. I would deny the remaining requests. The Greater Edwards Aquifer Alliance did not identify a member who would have standing in his own right. The Humphrey Cemetery Association failed to file timely comments articulating personal concerns, for example, about impacts to the cemetery. And finally, given the volume and the nature of this discharge, I think that Mr. Jennings lives too far from the proposed facility to be affected in a manner different from the general public. So let me pause there and see how you came out.
I'm in agreement on those 3 parties.
I am as well.
Okay. Turning to the issues, I would refer the following: whether the draft permit is adequately protective of the requester's health, whether it is protective of surface water and groundwater, whether it is protective of aquatic life, livestock, and wildlife, whether it is protective of existing uses and complies with TCEQ's anti-degradation policy, whether it complies with TCEQ's regionalization policy as described in Chapter 26 of the Texas Water Code, and finally, whether the draft permit adequately addresses nuisance odor in accordance with our rule. And I would again include an ADR referral and allow 180 days for the hearing.
I'm in agreement, and I might be jumping ahead, but I would deny the requests for reconsideration that are also out there.
Yeah, agreed. Thank you.
But I agree with everything else, yeah.
I'm in agreement as well.
I will attempt a motion then. I would move that we grant the hearing request of Martindale Water Supply Corporation, San Marcos River Foundation, and Texas Rivers Protection Association, that we deny all requests for reconsideration and remaining hearing requests, that we refer the matter to TCEQ's Alternative Dispute Resolution Program to run concurrently with SOA preliminary hearing scheduling efforts, that we refer the application to SOA for a contested case hearing on the following issues. A, whether the draft permit is adequately protective of the requester's health in accordance with the applicable regulations, including the Texas Surface Water Quality Standards. B, whether the draft permit is adequately protective of water quality. including the protection of surface water, groundwater, aquatic life, livestock, and wildlife in accordance with applicable regulations, including the Texas Surface Water Quality Standards. C, whether the draft permit's adequately protective of existing uses and complies with TCEQ's anti-degradation policy in accordance with 30 Texas Administrative Code, Section 307.5. D, whether draft permit complies with TCEQ's regionalization policy in accordance with the Texas Water Code, Sections 26.081A and 26.0282. And E, whether draft permit adequately addresses nuisance odor in accordance with 30 Texas Administrative Code, Section 309.13, and that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next items.
That takes us to our enforcement docket, which is items 4 through 22. The executive director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Amy Sedemeyer and Michael Parrish, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you items 4 through 22. The total assessed administrative penalties are $625,970, with $68,150 deferred, $73,547 applied towards supplemental environmental projects, and $484,273 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Colleagues, any questions?
Not at this time.
And Ms. Smith, has anybody signed in to speak?
We have folks signed in on 4, 5, 6, 7, 10, 12, and 17. They're here if the commission has any questions, but have not asked to address.
Thank you. And Mr. Sheldon, I guess, or is it Mr. Martinez? I'm not sure who's presenting on this one.
Sheldon is serving as my aide-de-camp, but I'll give the blurb for the office. Good morning, Commissioners, General Counsel, and Chairman. I am Eli Martinez, acting Public Interest Counsel, while Mr. Arthur attends to a family matter. We have reviewed these items, their proposed penalties, any comments submitted by the respondents, compliance histories, adherence to the penalty policy, notice and other procedural requirements. And at this time, we are satisfied these items do in fact comply with the relevant statutes, rules, and policies of the Commission. And OPIC is therefore prepared to support the adoption of the proposed enforcement orders listed in items 4 through 22 of today's Commission agenda.
Colleagues, I agree with that. Thank you, Mr. Martinez and Mr. Wayne. Appreciate that.
agree.
I'm ready to move forward. Commissioner Lindley?
As am I.
I am as well, and I can provide that motion. I move that we adopt items 4 through 22 as recommended today by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item 23 is the consideration of the monthly enforcement report, and the executive director's staff is again here to present this item.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me are Amy Sedemeyer and Michael Parrish of the Enforcement Division, and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2023 through April. There were 622 effective administrative orders issued, and of those, 80 contained supplemental environmental projects. These orders assessed a total of $7,736,877 in penalties, with a payable amount of $4,563,445. $2,190,177 are to be paid towards supplemental environmental projects. 9,659 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,373 enforcement action referrals have been received. There are 2,251 pending administrative orders with 1,076 cases that are on the backlog. 183 cases are pending at the Attorney General's office for representation in district court, and 12 judgments have been issued. 2,231 cases are being tracked for compliance. We've included for review a summary of OCE investigative activities for fiscal years 2021, 22, and 23, and we are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Colleagues,
No,
any
not this
questions?
time.
Thank you.
Ms. Smith, has anyone signed in to speak?
No one signed in on this one.
Okay, and Mr. Martinez, what is OPIC's view?
We have no comments on the report, but as always, we appreciate the efforts by the Office of Enforcement and Compliance that this report represents to ensure that the limits and protections of our issued permits are appropriately adhered to.
I do as well. Thanks for the report. Colleagues, there's no action necessary on this item, so Ms. Smith, when you're ready, please call the next item.
Item number 24 is the consideration of the adoption of amendment to 30 Texas Administrative Code, Chapter 9 regarding training. The Executive Director staff is here to present this item.
Good morning.
Good morning. Good morning, Commissioners, General Counsel, Special Interest Counsel. On behalf of the Executive Director, I'm Robert Eisnagel with the Human Resources and Staff Services Division. With me is Alma Borsheim of the General Law Division. For your consideration today is item number 24, the adoption of amendments to 30 TAC Chapter 9 training. This rulemaking changes the title of Chapter 9 from training to training and employee programs. Also, this rulemaking adds subchapter C, section 9.20, employee leave pool programs, to establish by rule the agency's leave pool programs and incorporate by reference the agency's policies to administer these programs. This new subchapter implements the rulemaking needed for the new family leave pool program created by House Bill 2063, passed by the 87th Texas Legislature in 2021. A public hearing was offered on this proposal in Austin on April 7th, 2023. The comment period closed on April 10th, 2023. No public comments were received. Staff respectfully recommends approval to adopt these amendments to Chapter 9. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you for your consideration. We are available to answer any questions.
Thank you, Mr. Eisnagel. I have none. Colleagues, any questions?
No.
Ms. Smith, has anyone signed in to speak?
No.
Mr. Martinez?
Good morning again. We've reviewed the Chapter 9 rulemaking before you, and we support its goals of confirming the agency's established sick leave pool policy and incorporating the new family leave pool created by HB 2063. And for these reasons, we support adoption.
Thank you. Colleagues, I do too. This is, no comments on a simple legislative implementation. I'm ready to adopt.
As am I. I would move that we adopt the amendment to 30 Texas Administrative Code, Chapter 9, as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you. Ms. Smith, when you're ready, please call the next item.
Item number 25 is the consideration of the adoption of amendments to 30 Texas Administrative Code, Chapter 113, standards of performance for hazardous air pollutants and for designated facilities and pollutants, and corresponding revisions to the Federal Clean Air Act, Section 111D state plans. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Michael Wilhoit with the Air Permits Division. With me is Terry Salem of the Environmental Law Division. This adopted rulemaking amends Chapter 113, Standards of Performance for Hazardous Air Pollutants and for Designated Facilities and Pollutants, to implement changes in federal emission guidelines for existing municipal solid waste landfills. Corresponding revisions to the Texas Section 111D state plan would be adopted concurrently with the revisions to Chapter 113 and are included under this docket. The proposed rules were published in a January 27, 2023 issue of the Texas Register. A public hearing was offered on February the 23rd, 2023, and the public comment period closed on February the 28th, 2023. The rule team did receive public comment, which was generally supportive of the proposed rules. In response to comments, the rule team added rule language to define the term reconstruction and to allow the executive director or local air pollution control programs to request additional documentation if needed to demonstrate compliance. In conclusion, staff respectfully recommends adoption of these amendments to Chapter 113 and the Texas Section 111D state plan. Additionally, staff respectfully requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. We're available to answer any questions.
Thank you, Mr. Wilhoit. I have none. Colleagues, any questions?
No?
Ms. Smith, is anyone signed in to speak?
No one is signed in to speak on this one.
Okay. And Ms. Jamison, good morning.
Good morning. Good morning, Chairman, Commissioners, General Counsel, and Executive Directors, attorneys, and staff. I'm Jennifer Jamison on behalf of OPIC for the record. Our office has reviewed this rulemaking as well as all related public comments, and OPIC agrees that revision to the Texas State Plan and corresponding Chapter 113 Municipal Solid Waste Landfill Rules is needed to conform to the EPA's emissions guidelines. Accordingly, OPIC supports adoption of this rulemaking as proposed by the Executive Director.
Thank you. Colleagues, I do as well. These rules or the guidelines are already applicable, and this just allows us to administer them. So I'm ready to adopt.
Agreed.
Likewise, I'll move that we adopt the amendments to 30 Texas Administrative Code, Chapter 113, and corresponding revisions to the Federal Clean Air Act, Section 111D State Plan for Municipal Solid Waste Landfills as recommended by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item 26 is the consideration of the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapter 290 regarding public drinking water and 291 regarding utility regulation for legislative implementation and staff-initiated revisions and deficiencies. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Christina DuPont with the Water Supply Division. With me is Michelle Risco with the Water Supply Division and Ruth Takeda with Environmental Law Division. The proposed rulemaking would amend 30 TAC, Chapter 290, Subchapter D, and Chapter 291, Subchapter L, for consistency with the Texas Water Code, Sections 13.1394 and 13.1395, to add weather resiliency requirements consistent with the after-action review of Winter Storm Uri findings and to clarify existing state rules. A public hearing will be offered on this proposal in Austin on August 11th, 2023. Staff respectfully recommend approval to propose the publication of and hearing on Chapter 290, Public Drinking Water, and Chapter 291, Utility Regulations. Staff also respectfully request permission to make non-substantive revisions to comply with Texas Register requirements. Thank you, and we are available to answer any questions.
Thank you, Ms. DuPont. I have none. Colleagues, any questions?
No questions, just comment that this is one of those rulemakings that so much work has gone into just proposal. So just appreciate what all y'all have done. And I know we're not adopting it yet, but I appreciate all the work that's already gone into this one so far.
Really well said. Not all rulemakings are created equally, and this is one where our agency really endeavored to reach out, communicate with the stakeholders, and examine a very critically important issue that became apparent to all of us in very sharp detail. So I look forward to the public's thoughtful response, and I'm grateful for the work that y'all have put into this so far.
I certainly agree with those comments. Ms. Smith, has anybody signed in to speak?
No one is signed in.
And Mr. Martinez, what's the view from the Office of the Public Interest Counsel?
Thank you. Our office has reviewed the proposed rulemaking to add weather resiliency requirements consistent with the after-action review of Winter Storm Uri findings. At this time, we support moving forward with publication and taking a public comment, and we will attend the August 11th hearing as well on this matter and apprise the Commission of any public interest issues we identify as the rulemaking process moves forward.
Thank you, Mr. Martinez. And colleagues, you're right. This is a big deal. You
Yeah.
know, Winter Storm Uri left nearly 50% of all Texans on under a boil water notice, disrupted water service, any water service, to hundreds of thousands of residents. And while this was largely a function of the power failures, our agency has a role in helping these drinking water systems build resiliency. So I'm excited about this project, and you know, both the legislative proposals and the work that our agency did to try to address this. And I want to reiterate the thanks to staff for all of the outreach that you did and the work that went into this proposal. I really want to thank also the stakeholders who accepted our invitation to be part of developing this rulemaking package, and I'm very eager to hear what they and our other stakeholders think about it. So all that is to say I'm ready to put this out.
Yeah,
for
you know, I'll
public
just comment that a lot of our rulemakings, this, what I'm going to say applies to, but this one just stands out to me because we have such teensy-tiny water systems and such huge ones. And so trying to land somewhere that is workable for all those size groups is hard. It's really hard. So I appreciate all the work that's gone into it. And I will make a motion. I move that we approve the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapters 290 and 291, as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item 27 is the consideration of the publication of and hearing on proposed amendments to Section 50.131C of 30 Texas Administrative Code, Chapter 50, Action on Applications and Other Authorizations. The Executive Director is here to present this item.
Good morning.
Good morning. Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Amy Browning with the Environmental Law Division. With me is Booker Harrison, also with the Environmental Law Division. The proposed rulemaking would reconcile an inconsistency between an agency rule and the statutory requirements of Texas Health and Safety Code, Section 382.061B, which requires Executive Director actions on permits to be reviewable by the Commission. The agency is proposing to delete 30 Texas Administrative Code, Section 50.131C1, and renumber the remaining parts of Section 50.131C. This will remove the exemption for a motion to overturn the ED's decision on registrations for authorization under an air quality standard permit. A hybrid virtual and in-person public hearing will be offered on this proposal in Austin on Monday, August 1st, 2023 at 10 a.m. in Building E, Room 201S at the Commission's Central Office, located at 12100 Park 35 Circle. Staff respectfully recommends approval to propose the publication of and hearing on Chapter 50, Actions on Applications and Other Authorizations. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you, and we are available to answer any questions.
Thank you, Ms. Browning. I have none. Colleagues, any questions?
No?
Seeing none. Ms. Smith, is anybody signed in to speak?
No one signed in.
Okay, and Mr. Wayne again. Good morning.
Hey, good morning again, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. For the record, I'm Sheldon Wayne with the Office of Public Interest Counsel. OPIC has reviewed this proposed rulemaking, and we agree with the Executive Director that it should proceed forward for publication and the taking of public comment. We understand that this rulemaking is necessary to correct an inconsistency between Commission rule and statute. OPIC will attend the August 1st public hearing for this rule proposal, and will monitor any future comments or meetings that take place as the process unfolds. At this time, OPIC is supportive of the substance of this rulemaking and further supports publication. Thank you, and I'm available for any questions.
Thank you, Mr. Wayne. Colleagues, our rules are not clear. This is an inconsistency. We need to fix it, and I'm ready to put this out for public comment.
I agree.
I move that we approve the publication of and hearing on proposed amendments to 30 Texas Administrative Code, Chapter 50, as recommended by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item 28 is the Chapter 106 Quadrennial Rule Review. It's the Chapter 106 is permits by rule, and the Executive Director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Gwen Rico with the General Law Division. Pending before you is item 28, the adopted rule review of 30 Texas Administrative Code Chapter 106 permits by rule. As required by Texas Government Code Section 2001.039, Executive Director staff conducted a rule review of this chapter to determine if the need for the rules within this chapter continues to exist. The proposed notice of the review for 30 TAC Chapters 106, published in the February 10th, 2023 issue of the Texas Register with a 30-day comment period. 3 comments were received on this rule review project. These comments were reviewed and determined to be outside the statutory and regulatory purpose of the rule review and will be considered when the rule is next substantively changed. Based on the review of this chapter, the Executive Director has determined that the reasons for the rules in Chapter 106 continue to exist. In conclusion, we respectfully recommend approval of the adoption of the rule review of 30 TAC Chapter 106. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with the Texas Register requirements. Thank you. The project managers and attorneys assigned to the chapters are here with us to answer any questions.
Thank you, Ms. Rico. I have none. Colleagues, any questions on this item? Ms. Smith, is anyone signed in to speak?
No one signed in.
Okay, and Ms. Jamison, good morning again.
Good morning again, Chairman, Commissioners, General Counsel, Executive Directors, attorneys, and staff. I'm Jennifer Jameson on behalf of OPIC for the record. Our office has reviewed this rulemaking as well as all related public comments, and OPIC supports adoption of the rule review and readoption of 30 TAC Chapter 106 permits by rule, with the understanding that all comments will be considered in any future policy or rulemaking actions. Specifically, OPIC encourages careful consideration of all comments and concerns regarding the use, protectiveness, and enforceability of the relevant permits by rule. With this understanding, OPIC supports adoption of this rulemaking as presented by the Executive Director.
Thank you, Ms. Jamison. There is still a need for this chapter, colleagues, so we'll readopt it. And as to the comments, we'll certainly keep those on file the next time that the rule is open so we can consider them.
I agree. I will move that we adopt the rule review and readopt the rules in 30 Texas Administrative Code, Chapter 106, without amendment.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next items.
The commission will be meeting in closed session in room 4220, or I'm sorry, in Building E, room 211S at, let's say, 10:05 approximately, as permitted by the Open Meetings Act, including Texas Government Code Sections 551.071 and 551.074, to take up and consider matters pursuant to items number 29 through 32 as posted and noticed.
The time is 10:05. We are in recess.
The commission met in Building E, Room 211S for closed session from 10:07 until 10:36 a.m. on items 30 through 32, as posted in notice pursuant to Texas Government Code Section 551074. No action was taken. This agenda stands adjourned, and the time is 10:42.